Dear students, subscribers and the viewers, welcome to the IAS Mentor. This would be lecture number 97 in the series Indian Polity, and this topic is a very unconventional topic, but however UPSC of late has been giving a lot of importance to what is called as alternate dispute resolution mechanism. So as we'll proceed, we'll try to understand as to what is ADR in the first place, and then we'll try to understand some of the legal mechanisms we have right now with regard to ADR, and then of course then we'll try to understand what are the various mechanisms of ADR, of course the laws and the other mechanisms of ADR, and then finally we'll do what is called as a practice question. As I've been telling the students many times, this series is going to be a wonderful series, extremely useful to a number of students. If you have seen the way that in the previous year UPSC has been asking questions, 15 to 16 question minimum has been coming from the subject Indian Polity, and many of my students who watched my previous series, they have messaged me they were able to at least attend 80% of the questions, provided that yes, you watch all the lectures in a chronological order. Not only watch the lecture, you also do the practice questions. So that is why in every lecture I give one practice question, and then after a particular topic is completed, I also do what is called as some practice questions. So this would be the last topic as a part of what is called as the Indian judiciary. So we have covered the Supreme Court, High Courts, we have covered topic like the subordinate courts, we have covered topic like public interest litigation. We also covered what is called as a tribunals in the last lecture. So the only thing that is pending right now with regard to the judiciary is the alternate dispute resolution. So basically what is ADR? That's the most important thing that you have to understand. What exactly does it mean by an ADR? ADR means alternate dispute resolution mechanism. So what does it mean by alternate dispute resolution mechanism? Instead of going to the courts, we will settle our dispute outside courts. It's an alternative mechanism to resolve our disputes. That's basically what is called as ADR. Now, what is the reason today the ADR is given lot of impetus? The ADR mechanism is actually promoted even by the government and by the judiciary. What is the reason today we promote this ADR? The reason as to why we promote this ADR today is that even the government and the judiciary wanted that less and less people have to go to judiciary, and more people, if possible, they should resolve their dispute outside the courts, because outside court settlement is a much complex, it's not a very complex process. The complexity of resolving the dispute become very less. There is a possibility of what is called as win-win situation. So all these things are possible only when it comes to what is called as an ADR, but not in a judicial system. So that's basically what we'll have to understand. So as we'll proceed, we'll try to understand as to what are the advantages of ADR as well, and of course what are the other legal mechanisms related to ADR. So as I already said, what is ADR? So the first thing that you have to understand when you talk of ADR is nothing but it is an out of court settlement, a settlement or opportunity that is available that is outside the court system. That's basically what is called as ADR. So what are the features of this ADR? That's very important before we proceed further. So first and foremost, the important feature of ADR is it is non-adversarial in nature. So what does it mean by non-adversarial in nature? So if you go to the courts, it is mostly adversarial in nature, because there is something which is called as prosecution, there is something which is called as defense, there is something who is called as a plaintiff and someone who is a defense again, but however defendant. So however, if you go to an alternate dispute resolution, it is not that someone is trying to punish another individual, but rather it could be on the basis of what is called as compromise. So the one of the important advantages of an alternate dispute resolution mechanism is that there is a possibility of negotiations, and there is a possibility of what is called as a constructive outcome. There is a possibility of compromise between the affected parties, which is not a case when they go to the courts. So therefore, one of the important advantages of ADR is that it is mostly non-adversarial in nature. Adversarial means it is adverse against one party, but in an alternate dispute resolution, it may not end, the result may not end which is adverse against a particular party. So it is non-adversarial. It allows for discussions and negotiations between the affected parties and thereby a solution can be brought in. So, that is also possible. And apart from that, the most important advantage is it is not having a rigid procedure. If you go to the courts, it will take up years for us to settle the dispute. So, that can be avoided when we take up what is called as an alternate dispute resolution, because the procedure is very flexible, the procedure is easy for the clients, and the procedure is also easy to pass the award. So, therefore, it becomes much more I would say much less complex to resolve these disputes, and then it also allows for what is called as a win-win situation. So, all these things are possible when it comes to what is called as an alternate dispute resolution. So, that is basically what you will have to understand. So, what basically is an ADR? An ADR is a mechanism by which you can go for out of court settlement. But the most important thing is that this out of court settlement should also be recognized by a law. So, unless and until it is recognized by the law, then it becomes illegal in nature. It becomes legal in nature only when it is recognized by the law. So, therefore, to promote the legality of alternate dispute resolution mechanism, two important laws has been passed by the parliament. So, what are those two important laws? We will try to understand that as well. So, two mechanisms that we have got today, one is what is called as the Arbitration and Conciliation Act, which has been passed by the parliament in 1996, and then we also got what is called as the Legal Services Authority Act 1987. So, what basically is the difference between these two mechanisms? One is the Arbitration and Conciliation Act, and other is what is called as the Legal Services Authority Act. The basic difference between them is this Arbitration and Conciliation Act is mostly used in case of what is called as commercial disputes. So, this is basically the difference that you should understand. It is basically used in case of the commercial disputes. Wherever there is a commercial disputes, this Arbitration and Conciliation Act is used. And then apart from that, you have what is called as the Legal Services Authority Act. So, this is used in case of what is called as normal civil and criminal disputes between individual parties. See, the key word is it can also be used in what is called as criminal disputes. Does it mean that people can go for alternate dispute resolution, that is out of court settlement, in all the criminal disputes? No, not in all the criminal cases, but mostly cases which are compoundable in nature. So, what is a compoundable offence? I will discuss that a little later, but try to put it into your ears that is possible in case of offences which are compoundable in nature. Compoundable offence means offences which are petty in nature. Alright. So, what are the mechanisms, legal mechanisms that you have got related to the ADR? We have two mechanisms. One is the Arbitration and Conciliation Act, which basically allows for two procedures. One is arbitration and other is conciliation. But however, in which nature of dispute this Arbitration and Conciliation Act provides for a legal mechanism or a legal sanction is in case of commercial disputes, which people enter into business, people enter into contracts to do business. And if there is any dispute between those people, then they can enter into what is called as arbitration and conciliation, an out of court mechanism to resolve this particular dispute. They can go to the court also, but if they want to settle it outside the court, then they can do it as per the Arbitration and Conciliation Act. People in case of ordinary civil and criminal disputes between the individuals, then they can go for an alternate dispute resolution. So, based on what is called as a Legal Services Authority Act 1987. So, this is basically what you will have to understand, and these are all the two mechanisms which provide legal sanctions to the ADR right now in our country. Alright. So, with that we will try to understand the first thing, that is basically what is called as the Arbitration and Conciliation Act. So, let us try to understand as to what is the mechanism that is provided by the Arbitration and Conciliation Act. The Arbitration and Conciliation Act provides for two mechanisms to resolve the commercial dispute. So, what are these mechanisms when it comes to Arbitration and Conciliation Act? So, first and foremost, we have understood the process is arbitration. So, one mechanism is arbitration, and then the other mechanism is what is called as conciliation. So, what does it mean by arbitration? So, arbitration is a form of what is called as resolving the disputes between the parties, which is out of court settlement. As the name suggests, arbitration means there will be a neutral arbitrator. That is what you will have to understand. A neutral arbitrator who is someone, you can assume that who is someone like a judge. So, someone like a judge is there. So, if there is dispute between two parties. Suppose let us assume A is there and then B is there. So A and B enter into a contract and there is a dispute between A and B. When there is a dispute between A and B, either they can go to the court to resolve their dispute, or if they do not want to go to the court, then they can go for what is called as arbitration as well. So in case of arbitration, so they will take up this matter to what is called as an arbitrator. So arbitrator is someone who is like a judge, but not exactly a court. So they will go to an arbitrator, they will present the case in front of a neutral arbitrator. The arbitrator will study the contracts and whatever is a dispute between the parties, and then finally the arbitrator will pass an order. But for all these things to happen, even before when these two parties enter into a contract, in the contract they should recognize an arbitration clause. That is what is very important. That means when I say that they should have an arbitration clause or an arbitrator that is possible or an arbitration clause, that means you should have an understanding that in the future if there is any dispute, while entering to the agreement they should agree that in the future if there is any dispute, they will resolve the dispute through what is called as an arbitrator. So only if there is a prior recognition of an arbitration clause, then they can go for what is called as an arbitration. So try to understand this in a very simple way. What is arbitration? If there are dispute between two parties, especially if it is a commercial dispute, either they can go to the court under the ordinary laws, or they can go to an arbitrator under the Arbitration and Conciliation Act, present their case, and the arbitrator will pass an order. A neutral arbitrator will pass an order after hearing the case from both the parties, and then that order is binding upon these particular parties. But however, what is the advantage? Unlike going to the court, if they go to the court, then it will be a very long process. So here the procedure is much simple, and therefore they can easily settle down their dispute. So this is basically what is called as arbitration. But they can also go for what is called as conciliation instead of what is called as an arbitration. So what is conciliation? How it is different from arbitration? While in arbitration, who is going to pass the orders? The orders will be passed by an arbitrator. Whereas in conciliation, the orders will not be passed by the arbitrator. There is only someone who is called as a conciliator. A conciliator is like a third party facilitator. So suppose let us assume again there is a dispute between A and B, where in case of arbitration, they will present the case in front of an arbitrator and the arbitrator will pass an order. So instead of that, if A and B appoints what is called as a conciliator. So what does this conciliator do? The conciliator does not pass any order. The conciliator only facilitates the dialogue between A and B. So the conciliator may give some advice to both A and B. Therefore, based on these advice and suggestions which is given by the conciliator, A and B both themselves come to an agreement, and then finally they will sign an agreement as to how to resolve their dispute. That's basically what is called as conciliation. So the basic difference between arbitration and conciliation is, in arbitration the arbitrator will pass the order, whereas in conciliation the conciliator will only give suggestions to the concerned parties, where the concerned parties themselves will come to an agreement and then they will sign the order. So that's basically what is called as conciliation. So I'm sure that you understand the difference between arbitration and conciliation, but however, try to understand, once in conciliation or be it in arbitration, once the award is passed by the arbitrator in arbitration, that is binding upon the parties. In conciliation, once the conciliator gives some suggestions, he cannot pass any order, but if the two parties agree to it and then they enter into an agreement, then they should be binding to that particular agreement. So that's basically what you'll have to understand. And while in case of arbitration, there is a need for prior arbitration clause, but there is no need for any prior conciliation clause. But even if there is no prior conciliation clause, they can appoint what is called as a conciliator. So these are all two important ways based on which the ADR functions basically when it comes to what is called as a commercial dispute. But it is not only in case of commercial dispute the government is trying to promote what is called as the alternate dispute resolution. The government is trying to promote alternate dispute resolution mechanism even in petty civil and criminal cases. So for that, one important law that has been brought in is what is called as the Legal Services Authority Act. Very, very important. Many times UPSC has asked question from this particular topic, so please pay attention to this. In fact, there are three important objectives of this important objectives of this Legal Services Authority Act. So, what are the three important objectives of this Legal Services Authority Act? So, first and foremost, yes, it provides for what is called as ADR. So, let me write it one by one. So, that is ADR, that is alternate dispute resolution in case of ordinary civil as well as criminal cases. Okay. So, of course, yes. So, this is one objective. So, it not only provides for ADR, that is alternate dispute resolution in ordinary civil and criminal cases, it also provides for what is called as legal awareness. So, one of the important objective of this act is also it wanted to promote what is called as legal awareness. So, how do you promote what is called as legal awareness? That is a secondary thing. That means in general, this Legal Services Authority Act, the objective is that to the common people of our country, they wanted to promote what is called as legal awareness. But how do they do it? We will try to understand that. So, one is yes, of course, it provides for alternate dispute resolution mechanism. It provides for what is called as legal awareness. And then the third thing is it also provides what is called as free legal aid to the poor people. So, this is very, very important. So, they also wanted to provide what is called as free legal aid, but to whom? But not to each and every citizen of our country, but to the poor people in our country, they wanted to provide free legal aid. So, this is in line with Article 39A of the Directive Principles of State Policy. If you see the Directive Principles of State Policy, one of the objective of DPSP is to provide what is called as free legal aid. So, they also wanted to provide what is called as free legal aid. So, these are the three major objectives of the Legal Services Act 1987. So, please keep it in your mind, very, very important. Okay, how all these things are to be achieved? So, first I said is that they wanted to provide what is called as ADR, alternate dispute resolution mechanism. And this alternate dispute resolution mechanism is available both in civil as well as criminal cases, but provided these offences are compoundable in nature. So, what do you mean by a compoundable offence? When I say the offence is compoundable in nature, these are all petty offences. Usually, the punishment for these offences is usually less than 2 years, not more than 2 years. But however, what are the compoundable offences is again mentioned in the Criminal Procedure Code, CRPC. But however, try to understand that only in case of petty offences there is a possibility, or petty offences there is a possibility you can go for what is called as alternate dispute resolution mechanism. Say for example, somebody has committed an offence of rape. Can he go for ADR mechanism to settle this particular dispute? No, that is not possible, because the offence of rape is not a compoundable offence, but an offence of theft, let us assume a petty theft, that may come under what is called as a compoundable offence. So, therefore, there is a possibility of what is called as ADR that is possible in this particular case. So, try to keep it in your mind. The first and foremost objective of the Legal Services Act is to provide for what is called as alternate dispute resolution. In what type of cases it is available? It is available both in civil as well as criminal cases, provided they are compoundable in nature. But however, the next thing is that what is a mechanism by which they can go for ADR, for which there is something which is called as Lok Adalat. So, under this act, the government can constitute what is called as Lok Adalat. So, what is this Lok Adalat? The Lok Adalat means People's Court. So, People's Court is a mechanism where if they want, so this is basically acting as a court where they can go and they can get their dispute settled outside the courts. That is basically what is called as Lok Adalat. The system is very simple. There is no need for any lawyer. There is no need to follow a rigid procedure. So, the affected parties, they can go. Suppose if there is any petty property dispute, the affected parties can go to the Lok Adalat, present their case, and then they can get their case resolved. So, this also provides for what is called as win-win situation. This also is non-adversarial in nature. This is also very cheap in nature, because you do not have to engage a lawyer. So, all these things are possible. So, this is to make sure that the people get justice very easily. So, that is why the ADR is provided. But this is just only one objective of what is called as the Legal Services Authority Act. Now, what is the second objective of this Legal Services Authority Act is that they wanted to provide what is called as legal awareness to all the people. Not just legal awareness, but also to provide what is called as free legal aid. That means, instead of people choosing to go for an alternate dispute resolution mechanism, suppose if they want to go for a court, any of the court for that particular matter, but if they want to go to a court, then they wanted to hire a lawyer, They wanted to have a lot of legal services for which they have to pay the lawyer, for which the poor people may not have what is called as a money to do all those things. And if they are not able to do all those things, then they are deprived of what is called as justice. But however, the constitution wanted to provide justice to everyone. So therefore, the poor people who cannot afford for what is called as a legal service, for them a free legal aid is given under what is called as a Legal Services Authority Act. So therefore, try to understand the threefold objectives of the Legal Services Authority Act is, first of all, they provide for alternate dispute resolution mechanism, and apart from that, legal awareness to all the people, and then the last thing is what is called as free legal aid. So these are the three objectives under what is called as the Legal Services Authority Act. But how do they provide what is called as free legal aid? How do they provide what is called as a legal awareness? For which you can understand, there is a list of, I would say, hierarchical associations, or I would say organizations, which are to be established under what is called as the Legal Services Authority Act. There are different nodal level agencies under the Legal Services Authority Act who will implement the objectives of this particular act. At the apex level, we have what is called as the National Legal Services Authority Act. So this is a national level authority established under the Legal Services Act, which will oversee that the objectives of this act gets implemented throughout the country. And in making sure that the objectives of the act is implemented throughout the country, in providing free legal aid, in spreading legal awareness, they will spread the legal awareness by conducting special camps to the people, so thereby giving them the legal education. And then apart from that, the National Legal Services Authority Act, in connection with the State Legal Services Authority Act and the Taluk Legal Services Committee and the District Legal Services Authority, they will also see that at every level there are group of lawyers who will be paid by the government, but there will be group of lawyers, and these lawyers' duty is to provide free legal aid to the poor people who are all eligible to get the free legal aid as per the Legal Services Authority Act. We will see who are the people who are eligible to get the free legal aid. So at the apex, you have what is called as the National Legal Services Authority. The National Legal Services Authority will be in touch with the State Legal Services Authority for every state, and the State Legal Services Authority will be in touch with the District Legal Services Authority in every district, and below that the Taluk Legal Services Committee. So depending upon where the people are, depending upon where their dispute, so they can reach to the Taluk Legal Service Committee, or at the District Legal Services Authority, or the State Legal Services Authority, or at the national level. So therefore, the people are given what is called as free legal aid, and they are also given legal awareness. Apart from that, if the people wanted to fight the case, of course, the poor people wanted to fight the case in the Supreme Court or in the High Court, the Supreme Court Legal Services Committee and the High Court Legal Services Committee also provides what is called as free legal aid. The free legal aid might include that they may appear for the poor people, the lawyers who are empaneled by the government, so they may appear free for these particular people, and they may provide other legal services like filing the cases or getting the judgments from the courts, giving other counseling when it comes to the legal matters. So these are all done free of cost, but however, all these things are done free of cost only for the poor people. So who are all eligible to get the free legal services under the Legal Services Authority Act is another important thing. Only these are the categories of people who are eligible to get what is called as a free legal aid. So who are the categories of people who are eligible to get the free legal aid? So here you can see that women and children are eligible to get, members belonging to scheduled caste and scheduled tribe, industrial workmen, so normally people who are considered to be laborers, industrial workmen, disabled persons, persons in custody, any of these category, persons in custody, persons whose annual income does not exceed 1 lakh normally, but if they have to take the services from the Supreme Court, Legal Services Committee, for those if the income is less than 5 lakhs, victims of trafficking in human being or victims of Bihar, victims of mass disaster, violence, flood, drought, earthquakes, industrial disaster. So all these categories of people are eligible to get what is called as free legal aid, and they can get what is called as free legal aid from the poor people. So that's basically what you'll have to understand. So apart from that, if they wanted to go for an alternate dispute resolution mechanism outside court settlement, they can also go for what is called as the Lok Adalat. So in the Lok Adalat, what type of cases will be done? Civil and criminal cases can be taken care. So this is basically what you'll have to understand. So normally only in case of compoundable offences they can go, but however try to understand what are the compoundable offences. These are all offences which are small, which are petty in nature. So either they can directly go for ADR to the Lok Adalat, or even if they have gone to the court, after some time the parties have gone to the court and they feel that they wanted to settle these disputes outside the court, then also they can come outside the court and they can go to the Lok Adalat and get their disputes resolved. So these are all some of the important things that you'll have to keep in your mind. So very important. So now before I complete this, I just wanted to touch upon another topic which is also what is called as the Gram and Nyayalaya Act. Now unlike whatever I have discussed, that is the Legal Services Authority Act as well as what is called as the Arbitration and Conciliation Act, if you see basically these two acts provides a legal mechanism or a legal sanction to out of court settlement, an ADR mechanism. But however, if you see the Gram Nyayalaya Act, the Gram Nyayalaya Act is not completely an out of court settlement. It is not an ADR mechanism, but it is a normal hierarchy of courts. It allows people to go to the court and settle their dispute. So normally when people have any problem, they go to the court, they have to go to the court and get their dispute resolved. But however, not every citizen of our country is capable of approaching the court and getting their problems settled. So therefore, the idea of Gram Nyayalaya is bringing what is called as mobile courts, bringing courts to the doorsteps of the peoples. That's basically what is called as Gram Nyayalaya. So for which an act has been passed by the parliament, the Gram Nyayalaya Act. And so as per this particular act, there will be someone who is called as Gram Nyayadhikari. So what is the purpose of this Gram Nyayadhikari? So this Gram Nyayadhikari is a judge who is a judge at the level of what is called as first class judicial magistrate. So judge of the level of first class judicial magistrate will be appointed as a Gram Nyayadhikari. So such courts will be established as a mobile courts at the panchayat level, at the intermediate level. You know that the panchayat system in our country has got three levels. You have a district court, then you have an intermediate panchayat, and then you have what is called as the panchayat at the village level. So the panchayat at every intermediate level, there will be what is called as a mobile court, and that mobile court will be presided by what is called as a Gram Nyayadhikari. So this Gram Nyayadhikari will function as a mobile court. So he will reach to the doorsteps of the people, look into their cases and settle the disputes then and there itself. So this is basically what is called as the Gram Nyayalaya. So try to understand the Gram Nyayalaya is part of the regular court system, but however this is a concept of what is called as a mobile court, the court going to the doorsteps of the people. So that's what you'll have to understand. But however, one exception under the Gram Nyayalaya Act and the way that the Gram Nyayadhikari function, so he does not strictly follow the rules as laid down by the law, but however there is also a possibility of what is called as conciliation through which the matter may be resolved. If the affected parties who come to the Gram Nyayadhikari, if they feel that they wanted to go for conciliation, so the Gram Nyayadhikari may also allow for what is called as conciliation. So conciliation is that a third party can be appointed who may facilitate the process of resolving the disputes, and if the parties agree, accordingly the case may be resolved. So this is basically what is called as the Gram Nyayalaya Act, and that is how the Gram Nyayadhikari functions. But however, try to understand whatever is the order that is passed by the Gram Nyayadhikari, it is just like an ordinary court. So therefore, if the concerned parties are not happy with this particular judgment, they can go for an appeal against the order of the Gram Nyayalaya court or the Gram Nyayadhikari. So the next level of appeal usually is there in the district court. So probably they can make an appeal in the district court. But however, there is no appeal against what is called as orders that is passed by the Lok Adalat. There is no appeal against what is called as arbitration and conciliation, and also the orders that is passed by the Lok Adalat under the Legal Services Act, because they are all completely out of court settlement. They are alternate dispute resolution. If they are not happy with the orders that is passed by the ADR mechanism, they can make a fresh case in the court, but they cannot make an appeal in the court of law. They cannot make an appeal in the higher court because they are out of court settlement. They are not normal court settlement. But whereas in case of Gram Nyayalaya, if an order is passed by Gram Nyayadhikari, and if they are not happy with this particular order, they can make an appeal against the order of the Gram Nyayalaya or the order that is passed by the Gram Nyayadhikari. So, this is basically what you will have to understand. With that, we are coming to the end of this particular lecture. So, look into the question. Consider the following statements. Only compoundable offences may be taken by the Lok Adalat. Is it only the compoundable offences? So, come to statement 2. Arbitration and conciliation are part of alternate dispute resolution mechanism. Gram Nyayalaya has jurisdiction only in civil but not in criminal matters. In fact, the Gram Nyayalaya has jurisdiction both civil and in criminal matters. So, this answer I am saying it here. So, how many of the statements given above are correct? 1 only, 2 only, 3 only, D none of the above. So, please try to put your answers in the comment box. Please do participate in all these things. That is going to extremely motivate me in making the further videos. So, we have completed most of the concepts related to what is called as ADR, and in the process we have understood what is Arbitration and Conciliation Act and also what is Legal Services Authority Act. Then we also understood what is called as the Gram Nyayalaya Act and how the Gram Nyayalaya Act is different from the alternate dispute resolution mechanism, though it provides for what is called as the process of conciliation. So, with that we are completing this particular lecture. From the next lecture, I will start what is called as a center-state relationship. If you have any queries or concerns related to this particular lecture, please do reach out to me. So, please do not hesitate. Think me as a friend or a guide or a mentor, whatever be it, please do reach out to me. As I have been saying number of times, many of the students who have watched the lecture has been immensely benefited out of this particular series. I have done a series before this also, and many students have reached out to me and they were able to do 80% of the questions that was asked in UPSC examination. It is not just 80%, you can even do more. So, please refer this series to your friends and family members who are preparing not only for the UPSC examination, but also for other competitive examination. This is going to immensely benefit all of them. Thank you very much. All the very best.